question is, do you want this instruction read or modified in any way?
You just said I got a constitutional right not to testify or to testify. I didn't make either one of those decisions, so I don't understand.
The jury instruction is typically read when a defendant does not testify. In every other case that I've had, the decision on whether to testify was a decision made by the defendant personally. In this case, the court found that you forfeited your right to testify based upon your conduct. That is the ruling I made this morning.
How did I make that decision, though? I didn't.
My question to you
say yes or no.
Do you want the jury instructed that your silence must not be considered by them in any way and must not influence their verdict in any manner?
What do you mean my silence? My Fifth Amendment right?
Correct. I'm not hearing a request from you to have the jury
because
given this instruction.
I don't understand why you're asking me the question, Your Honor. I never decided to or not to testify. I never decided either way.
I understand that.
So how can I answer that? I don't understand why. I don't understand.
We are now at the moment where we are discussing whether the jury should receive an instruction specifically on you not testifying, irrespective of the reason for that. I believe I could modify this instruction to simply say a defendant's silence or a defendant not testifying should not be considered by the jury in any way and must not influence their verdict in any manner. Are you making such a request for a modified instruction?
I don't understand the question because I never decided to or not to testify.
I understand. I understand what you're saying, sir. I really do. But in light of the court's decision that you forfeited your right to testify,
how did I forfeit something I never said?
Do you want the jury to be instructed something to the effect of they cannot use your silence, meaning they cannot use you not testifying against you in any way?
I don't understand because I never made a decision not to or to testify.
I'll ask you one more time, and if you do not answer with a yes or no, I will take your answer of not answering as you are not making a request for a modified instruction.
How can you do that,
Your
Your
Honor? Do you want this court, sir, to instruct the jury in any way regarding you not testifying in this case?
I don't understand the question.
All right, then based upon there has not been an express request made by Mr. Brooks to give either 315 as it's in the standard or pattern jury instruction or a modification as this court has suggested, 315 is to be taken out of the jury instructions.
How are all these decisions being made without me understanding?
Then I have looked over the verdict forms, and other than really what I would describe as some consistency in how phrases, whether there's all caps, not all caps, but
all caps,
what we call the sentence capitalization for the charges. For example, I want to be consistent with how I spell out first degree intentional homicide or first degree recklessly endangering safety. There was just sometimes it was capitalized, sometimes it wasn't. So we're looking through all of that to be consistent. I want to make sure the word information is capitalized since that's the charging document, things of that nature. It is my practice, and you should be aware, Mr. Brooks, that I always put the not guilty verdicts on top when I hand all the verdict forms to the jury. And by that I mean it's by charge. So they're collated, if you will. So the not guilty followed by the guilty for counts 1 through 76.
You said it's collated. What do that mean?
So I put the not guilty, then the guilty for count 1, followed by the not guilty and the guilty for count 2, and so on and so forth, all the way through the remainder of the counts that are alleged in this case, which in this case total 76.
I don't understand. So how?
I looked at the special questions that are on the guilty verdicts only. They did appear to be proper. Again, just some grammatical things, but I believe those are all accurate.
Can I go to the other courtroom? Since you don't have to answer any questions, but I have to answer all, can I just go to the other courtroom?
Not at this time.
Why not? I keep telling you I don't understand these proceedings, and you just keep running right over my rights, like you don't even hear me saying anything.
Attorney Basie, are you handling the verdict forms? Go ahead.
Can I go to the other courtroom, please?
Are you waiving your right to be present in this courtroom?
I'm not waiving anything.
Then the answer is no.
I'm making a request.
Then the answer is no.
Then how's it? So what? You gonna try to force me to interrupt and do all this so you
I'm
can
not
make the
forcing you,
record
sir. I'd
and
like
make
you
it
to be
seem like
here.
I forfeited something that I came in here as soon as we got on the record and made a request to not be present for these proceedings. But when I'm making a request to avoid the drama and all that,
Sir, the only one with the drama is you.
it's you too. You the big contributor to the whole thing.
Mr. Brooks, I have to preside over this case. I
Yeah,
have
and
to
you haven't
make
been
determinations.
impartial or fair yet.
Mr. Brooks, I have a question to the state. I ask that you not interrupt, and then
It's not about me
response.
interrupting. It's about me attempting to understand. I've been saying that since we came in here.
Mr. Brooks, I
You
will.
can't-
I
you
will
can't
respond
force me to
as follows
understand.
to that. You waived your right to counsel.
I didn't waive my right to no